All right. So let me go ahead and end that poll for everyone. Thank you all very much for providing that bit of information. And let's get back to our main webinar here. Take this a little bit to load. Here we go. All right. So again, good afternoon, everyone, and welcome to today's webinar, Defending the Forensic Interview in Court. My name is William Moore, and I'm with OJJDP's NTTAC. And before we get started with today's webinar, I'd like to make a few announcements for you all regarding the technology to keep in mind. Please note that today's webinar is being recorded and will be available on NTTAC's YouTube page. You can view archived videos and webinars on NTTAC's YouTube page. If you'd like to receive any supporting materials related to those videos that you view on our page, you could feel free to reach out to the OJJDP TTA Help Desk and we can get those items on over to you. For those wishing to download a copy of the PowerPoint and even other important documents related to today's webinar, you can do so by locating the Handouts pod. At the Handouts pod, you can simply click on the name of the file and then click the download button, and it will download those documents directly to your device that you're joining from. During today's Q&A, we will have an opportunity for folks to ask questions to our presenter. During the presentation, you can feel free to submit your questions in the chat box. Just simply type your question and hit either enter or the bubble icon, and it will send the questions on over during our Q&A portion. Feel free to submit those questions throughout today's presentation. And to get a little practice with that chat box, please take a few minutes to help us count. We want to know how many individuals are joining in a group. So if you could take a moment, please type in the total number of additional people in the room with you today. If you're viewing by yourself or alone, there's no need to type anything at this time. However, if you're viewing with additional individuals in the group, please type the total number of additional people in the room with you today. So for example, if it's me and my mom watching today's webinar, then I would put +1 because it's one additional person with me. So please take a moment to let us know how many additional people are in the room with you today viewing today's presentation. If you're viewing alone, there's no need to type anything at this time. Now, in regards to that, please note that individuals who are signed in to Adobe Connect will receive an automated certificate of attendance via an Adobe Connect automated email. When you receive that, you will get that for the individual who did sign in. If a person is participating in a group and is not signed in, they will have to complete the group validation form. You'll just simply download that form, complete the name or the information for the additional individuals that have joined, and send that over to the email address that you see here on the slide, and we can get the certificates for those additional individuals who are viewing in the group. Take a moment to review today's agenda. And that being said, I'd like to turn it over to Rachel for today's presentation. Rachel, take it away.
Awesome. Thank you so much, William. First of all, I want to say welcome to everyone. It's so great to be here. Thank you so much for spending the afternoon with us. Before we get started, I'm going to introduce myself. My name is Rachel Johnson. I am a forensic interview specialist with Zero Abuse Project. Earlier on in my career, I worked quite a bit in domestic violence and sexual violence advocacy, and then moved over, into working within family crimes, and then specifically within child advocacy centers and within the multidisciplinary team environment as a forensic interviewer, as a coordinator of a forensics program, also working in managing a multidisciplinary team, as well as in prevention education. Most recently in the state of Minnesota, I am based in Minneapolis, Minnesota. I worked for our state coalition, the Minnesota Children's Alliance. And while I worked for the Minnesota Children's Alliance, my role was a little bit unique. I had the opportunity to work not only in training development, as I am right now with Zero Abuse Project, but I also got to work with a number of multidisciplinary teams and child advocacy centers across our state as kind of a float forensic interviewer. And I say that because one of the things that I want you to know is that in addition to doing training and development types of things with Zero Abuse Project, I still currently work as a forensic interviewer. So I'm still conducting forensic interviews with a few different child advocacy centers and multidisciplinary teams across the state of Minnesota. And so I'm sitting in that chair, just as you are sitting in that chair. And I'm still receiving subpoenas. So a lot of what we're going to talk about today is coming from my experience, things that are coming up for me now within cases or have come up historically, in addition to thinking about some of the professional development and preparation pieces that you can begin now, even before you've even conducted a lot of forensic interviews or even before you're ever subpoenaed. There are a lot of things that we can do as forensic interviewers or as multidisciplinary teams to best prepare ourselves when we do get that subpoena or we find out that that case is going to go to trial. So a lot of what we will talk about today, again, will focus on your professional development, on our multidisciplinary team development, and then some concrete skills around specifically how you testify and what that looks like and what those conversations and preparations should look like. Before I move forward, I am going to turn off my video just to help us with avoiding any sorts of internet or technology issues. I do ask you, if you have trouble hearing or there's some sort of issue as we're moving forward, please let me know within the chat function, and so we can get that sorted out as we're moving forward. So let's jump into our content today. Like I talked about, we're going to talk today about defending the forensic interview in court and the importance of preparing with your prosecutor and what that conversation should look like. And as I just kind of talked about, part of the reason that I really love discussing this topic is because the act of testifying in itself can be very stressful and very, very nerve-wracking. And so starting to think, even if you are early in your career, so as we saw in the poll, there's some folks that don't have very minimal knowledge with regard to testifying or moderate knowledge with regards to testifying. There's a lot of things that you can begin even in your early preparation as a forensic interviewer in order to ease this process when you get that subpoena. Again, we know that sometimes that trajectory of that case, you're not actually going to defend your interview in court or speak to your interview within the court process for sometimes a year or more afterwards. I'm thinking about right now, I just recently received a subpoena and I first interviewed this child in 2015. So because of the nature of the case, because of other sorts of elements that were brought in and some additional circumstances around this case, I'm not even going to be testifying to that case until almost 5 years later. And so again, that preparation and also thinking about how we incorporate best practices throughout the trajectory of both the forensic interview and our multidisciplinary team approach before and after the forensic interview is going to be really, really important when we think about the fluidity with which these cases can come about and move forward. So that's what we're going to be talking about today. So you find out that you're going to be going to court. One of the first things to think about is what is going to be asked of me? What is that going to look like when I go to court? So thinking about the types of questions that you are going to be asked when you go to court. So being able to explain who exactly you are, what your role is, what your education is, and what your training is. Thinking also specifically too about what your team approach is to your forensic interview, what type of protocol you're using. And we're going to talk a lot about protocol and a lot about explaining and describing our protocol use. But one of the things that I want to think about when we're taking a step back is who our audience is when we're going to court. So we have our prosecutor who is going to be facilitating that interaction, but ultimately in a criminal case, our audience is going to be that jury. And while you working with your prosecutor and with your team will have a mutual understanding of a lot of the acronyms and technical knowledge that's going to be involved in the type of work that you do, your jury isn't going to necessarily have that extensive knowledge. When I think specifically about forensic interviewing and I think about in areas or scenarios where I'm talking about my job and what I do, Most folks don't really know what a forensic interview is or what this interaction looks like unless they've had some sort of personal experience or personal connection, or they do some sort of adjacent work to forensic interviewing or child protection, which we know is a very, very limited amount of folks. We also know that based on what that jury selection process with, folks that maybe have some of that information or that knowledge or are part of an adjacent role may not be permitted to be on that jury. So we want to assume that the folks in our audience in this particular environment are going to have very, very limited knowledge about what we do. And I say this because when we're thinking about some of the early ways that we can begin some of our court prep, these types of questions are questions that we want to get really, really comfortable answering in a very simple and concrete way. And that's something that you can do, not even thinking about case specifics or thinking about, the fact pattern or what was said within a particular case. You can start thinking about how you would approach these questions in a really concrete and accessible way. I think about, for me, when I first started testifying, in some of my earlier cases testifying, one of the things that I did was I asked a colleague that really had a very limited knowledge about forensic interviewing and about my role and what exactly I did. And I asked that person to ask me these questions so I could have the experience of explaining to them what I do, what the interaction looks like, what the interaction sounds like, so that I could see, are the ways that I approach talking about my work and talking about my role accessible, again, to a person that has really, really limited knowledge about what's happening. Because, again, we have a lot of, we're always talking within this field about research and knowledge, and that research and knowledge is important in so much as we're able to explain it to the audience that needs to be able to understand what we're doing, to really understand that reliability and that validity of that interview and how we gather that fact pattern in that interview and we gather that evidence in that interview. So we want to make sure that that audience understands what we do and why we do it. So again, in addition, we want to explain what a protocol is and explain the protocol that we used. Again, this is one of those areas where we want to think about what is that definition of a forensic interview. We want to be able to explain that it is neutral, fact-finding, that it's a session conducted by a specially trained interviewer, that we're using a multidisciplinary approach, and that it is in a response to an allegation of alleged maltreatment. So it's a purposeful interview, and we're going to want to explain what exactly that is, and we'll want to explain that methodology that we use to approach that interview. So that is our protocol. And again, I think that protocols oftentimes can be the subject of some of the defense attack strategies when it's coming to defending our interviews. So we're going to dig deeper into that, but we want to be thinking about how we explain that. We also want to be thinking about how we explain the research that dictates what we do. Research is very, very important within our fields, and we know that there are thousands of pieces of new research that emerge each year on the different elements of our practice and elements of our field. We also know that one of the requirements of our nationally recognized protocols is to go through a process where they are updating their approach or their protocol based on new and emerging research. And so we want to be connected as forensic interviewers into the different forums that talk about what are the new things that we're learning about how we approach the interview. And I'm going to give some kind of concrete examples of that later on. And how to get connected with some of those resources. But, are you continuing your education as a forensic interviewer and taking opportunities to absorb new information and new findings and best practices within our interview process? Also, peer review. So do you participate in peer review? So it's not just getting trained in the protocol, it's not just doing forensic interviews, but are you receiving feedback? And as a multidisciplinary team or within another forum, such as a national forum, again, are you getting feedback on how to improve your process and improve your practice as a forensic interviewer? And again, this other question, what is a CAC? And I love on this slide too that it has the acronym of CAC because this is a perfect teaching point, right? So we use this acronym of MDT, CAC quite a bit. You'll hear me say that quite a bit because we're used to and pretty comfortable with those acronyms within our field. But the folks, our audience within this particular environment, our jury, aren't going to be familiar with those acronyms that we have in our field. Even when we say Child Advocacy Center, we want to be able to explain what exactly that is and what it means, and what the role and the purpose is. I've even seen sometimes prosecutors, with regard to the Child Advocacy Center, the multidisciplinary team, ask some additional detail about, what the environment of the Child Advocacy Center looks like. So what is the experience of children and families when they go to that Child Advocacy Center, to really show that part of the approach and part of that environment is to reduce that suggestibility by creating a neutral and child-friendly environment. So when talking with your prosecutor, you'll want to also talk about some of the extent that you will explore talking and explaining some of these concepts. Here's some other pieces that, especially if you are a newer interviewer, you can already start working on. So keep a current or updated curriculum vitae or resume. This may sound very, very trivial, but when you're thinking about your court preparation process and you're thinking about reviewing your video from your forensic interview, reviewing those reports, the last thing that you're going to want to have to do in addition to that is trying to find every certificate from every training that you've attended in your last 5 years, 10 years, 20 years for some folks, more for some folks within your field or within your career, to really show and to demonstrate that credibility and that continued training and education that you have within the field. So one of the things that I highly recommend for forensic interviewers, and especially when I think about onboarding processes that I've gone through with new forensic interviewers, is I tell folks right away, start to compile that CV. I had a mentor within the field that had showed me their CV for forensic interviewing, and one of the things that I love that she did is, in addition to having the various trainings that she went to, she also included the particular sessions that she had gone to, or when she had been doing training, she included the particular topics that she had done training on. And this can be important because I've seen sometimes defense strategies where they will agree that you have a foundational knowledge in the field of forensic interviewing, but they may try and kind of diminish your credibility about a particular dynamic within a case. So they may say, yes, you do have training in a forensic interview protocol, but do you have training with specificity around commercial sexual exploitation or around physical abuse or neglect? What gives you credibility in questioning a child about the elements within these kinds of multifaceted forms of abuse or maltreatment? And so you want to sometimes be able to explain, I actually attended additional training on some of these specific topics. So again, whenever possible, you can't have that CV be too specific and too much information, and so really record as much of that as possible. The next piece too, keeping track of how many interviews you conduct will also be important. I know sometimes folks get worried because maybe they've only conducted 10 interviews or 15 interviews or 20 interviews, especially if you work for a smaller jurisdiction where maybe you only have 1 or 2 or 3 forensic interviews within the year. You may think that that number is very, very small. But that's part of why it's important then to additionally amplify within your CV or your resume by talking about the ongoing training, by talking about, I even like to include personally the dates that I've been peer reviewed to show that I'm peer reviewed multiple times in the year. So even if I'm not doing a lot of interviews over the course of a particular year, I can talk to the fact that there's quality control and I'm receiving feedback from my colleagues within the field. And so again, even if your number with the amount of interviews you conducted are smaller, you can amplify that by talking about continuing education, feedback that you're getting within the field. I've also heard, and this may be something to bring to your prosecutor's attention, where I've heard prosecutors, especially with interviewers that maybe have fewer interviews conducted, will ask them to kind of estimate how many cases they've been a part of on a multidisciplinary team. So for me, when I first started interviewing, there was a few months after I got done with forensic interview training that I just observed the other interviewers that I worked with. So I wasn't conducting interviews, so my number would have been small. but I, over the course of those few months, maybe observed, a dozen or 24 interviews. And so I've also heard prosecutors amplify that number by asking you about how many you have observed or participated as a multidisciplinary team member with. As it says here too, think about that training that you've received and those ongoing training hours. We talked about this a little bit, but having that understanding of your child advocacy center and how things work and who does what. I think this is also really, really important to have an understanding of that delineation of roles, because I see a lot of times defense attorneys will maybe try to hold you accountable in your role as a forensic interviewer for making decisions that maybe you are not a part of. So this can get a little complicated if you are a person who is also a law enforcement investigator and a forensic interviewer, or a child protection worker and a forensic interviewer. But for me, as a professional forensic interviewer, once I had a defense attorney who was saying, you're part of a multidisciplinary team, basically was saying, why didn't you tell this child then that they had to go get a medical exam? You make these decisions as a multidisciplinary team. But the reality is, for me, within my particular role as a forensic interviewer, yes, I'm part of the multidisciplinary team, but for me, in that role of a forensic interviewer, I don't make, the decision about whether or not a child has a medical forensic exam. So again, they were trying to use my role adjacent to the MDT to try and insinuate that I hadn't done a part of my job, or that I didn't think that this allegation was credible because I personally didn't mandate the child to go get some sort of medical forensic exam, which again, is adjacent to my role as a forensic interviewer, multidisciplinary team member, but was outside of the scope of my role as the neutral fact finder as the forensic interviewer in this particular case. And again, we also want to know the policies and procedures of your multidisciplinary team approach. There is a case that one of my colleagues told me about recently where the team had deviated from what their typical MDT response was when it came to the type of case that they were looking at. And so they actually had subpoenaed the CAC director to come in, and the defense attorney asked the CAC director about what their typical operating procedures were to basically try and create the shadow of a doubt about the approach that had been taken within this particular case, and to show a discrepancy to make the investigation look like it was not credible. So we want to be really, really mindful of that. If we had to deviate from our typical policies or procedures or operations, having an understanding about where those deviations were made and the purpose behind them, so that if we receive a question about that, we'll be able to explain that. I have seen defense attorneys want copies of the MDT guidelines or the MDT protocols and have compared the trajectory of the case to what is outlined within those to try and find discrepancies between what was done and what is outlined within those MDT protocols. So again, something else to be mindful of. So what do I need to know as an interviewer? Again, the field of forensic interviewing is ever changing. So I think one of my biggest pieces of recommendation is really get connected with the different organizations that dictate our field, because they're really, really great at synthesizing and connecting you with the emerging research and issues that you need to know and be able to speak to as an interviewer. I think a really good concrete example of this is how in a lot of our nationally recognized forensic interview protocols, we now have expanded processes or multi-session processes. That's something that is supported by research and has been seen as credible. Again, it requires additional training, and it's purposeful. It's not another bite at the apple. It's not continuing to do multiple interviews because the child didn't give you the information that you perceived ahead of time, right? No, we're not doing that. We're doing it for a purpose. It's a standard interview that's broken up over multiple sessions. But again, there is historical background within our field that says there should never be more than one interview, right? But we know that that has shifted and emerged and changed. So we want to be able to speak to that, because if we are defending an expanded interview, we want to be able to talk about how our practice has evolved. Yes, you may find old research that says never do a multi-session or an expanded process interview, but here's what we've learned through new research within our field. So when we're thinking about some of those organizations, again, the National Children's Alliance, if you're working with a child advocacy center that's accredited by the National Children's Alliance, you may already be connected with the National Children's Alliance, especially with regards to the standards. So they are the ones that are giving us guidance on how much peer review we should be getting in the year and what types of continuing education and other standards for our multidisciplinary teams. APSAC, so the American Professional Society on the Abuse of Children, they have practice guidelines as well. And those guidelines, again, govern how we approach forensic interviews and the best practices that should be present regardless of protocol that's being used. There's also the National Association of Certified Forensic Interviewers, another organization, and then the Forensic Interview Specific Special Interest Group through the American Professional Society on the Abuse of Children. So I strongly recommend going and seeking out these organizations. AFI, the Association of Forensic Interviewers, is actually a program that we house. It's a multi-protocol program. You can email me if you're interested in being in the Association of Forensic Interviewers. It's really meant to be another space or forum. There's some guidelines for practice that are included with that, but again, it gives us another professional organization that you can be a member of to speak to, again, that guidance and that oversight that's given within our field. What else do you need to know as an interviewer? We have to continue to improve our skills and abilities, so making sure that we're well trained. Again, we talk about this with protocol training. Going through a 40-hour protocol training doesn't necessarily mean that you are ready to go and conduct an interview. It's important to observe interviews, to get practice, to be doing mock interviews, to practice your skills, right? So in addition to a 5-day forensic interviewing training course, you want to be going to ongoing and advanced trainings, also peer review and supervision. And again, this is another piece that I think is really, really critical to bring back to your multidisciplinary team. So if you do not have a peer review process, either within your agency, your child advocacy center, or within your multidisciplinary team, this is something that you can establish to really help bolster the credibility of your team, the credibility of your forensic interviews. We are working right now at Zero Abuse Project on a national peer review and mentoring program that we're going to be putting forth. A few different ways that this can be done. One of the things that I absolutely loved, I had mentioned my mentor and a former colleague earlier, but one of the things that she did with us for peer review is we would do an internal session where we would take a forensic interview and we would go through with kind of a comment feedback sheet, and we actually start and stop through the interview process and talk with the interviewer who had conducted the interviewer about, what were you thinking, at this point? What are different places that you could have gone? How productive do you feel your line of questioning was? And then from using those types of questions, just talking about what are strategies when we get this type of disclosure, we see this kind of block within an interview. It wasn't to say that the interviewer had done something wrong, but it just gave an opportunity to think creatively about all of the different places that we can go within our interview process. So that's an example of an internal peer review where we have forensic interviewers critiquing and offering guidance on to other forensic interviewers, but this can also happen on a larger multidisciplinary team level too, because sometimes having that feedback from the investigators and having that feedback also from your prosecution can be really, really helpful, because they can help connect you as a forensic interviewer with what some of the implications of certain questions that you ask, what that might look like or how that might play out later on, or what types of details or elements may not be present. And so again, it's very, very important for interviewers to be receiving feedback from other interviewers, and then also it can be helpful to have interviewers work within their multidisciplinary teams to do peer review and feedback as well. When it comes to protocols, so I had mentioned this a little bit earlier, one of the things that I want to say about protocols is a common defense attack that would happen earlier on is this idea of pitting the forensic interview protocols against each other. So saying, Rachel, you did this interview in the Child First Protocol, how come you didn't use NCAC or NICHD or Tom Lyon 10-step protocol, to try and diminish the credibility of the interviewer based on the type of protocol that they had used. In order to try and challenge this defense critique, there's actually this really, really amazing coalition of professionals. There's representation from all of the nationally accredited protocols that met together and decided to come up with what the agreed upon best practices are across all of the protocols. And that's this document right here. It's the OJJDP white paper on best practices within forensic interviewing. Victoria has just put the link for that in the chat for you all. And what I love about this document is it's very, very concrete and simple to read. So it's a shortened document, but it's a phenomenal synthesis of all of the research that creates the foundational elements of our forensic interview protocols. And again, it really helps with that defense attack of trying to pit the protocols against each other. So all of the nationally recognized protocols came together to say these are, this is the foundational basis for what we do and why we do it. Again, what that looks like in practice may be different across the protocols, or the tools or implements that are used may look different. But again, this is the research that we're basing the decisions about how we approach the interview in. And so when I testify, especially if I'm working with a jurisdiction that I haven't worked with frequently, or maybe have less specialization in child abuse cases, I really like to give them, 3 main articles. So I'll give them this OJJDP best practices in forensic interviewing article. I'll give them the APSAC, forensic interviewing guidelines. And then I'll also give them, another document which I'll talk about in a little bit, which is going to be the position paper on Dalton diagrams. And we're going to talk about Dalton diagrams here shortly. But again, is another resource because within the protocol that I typically interview in, Child First, we do use Dalton diagrams. And again, that can be another place for defense attack. And we'll get there in a little bit. This is actually, it's funny because when we wrote this particular training, this article was not out yet, but it is out yet. And again, Victoria will put the link for this within your chat box. But what they actually did is the American Professional Society on the Abuse of Children wanted all of the nationally recognized protocols to publish an overview of where their protocol is at currently, changes, shifts, responses to some of the emerging research in the field. And so this is a really, really awesome update on all of the protocols, and again, shifts or changes in practice, or again, other sorts of incorporations based on what we've learned in the research recently. So that just came out this year and is a very, very helpful tool regardless of what protocol you're using. One of the things that I want to encourage you to do is to stay true to your protocol. So sometimes sometimes people want to make a little bit of a Frankenstein protocol. So they'll want to take the rapport section from this protocol and then attach it to a transition section from another protocol and a different approach for exploring details or substantive matters. And what I want to say is that, when we're thinking about a protocol, while they're all based on the same research, there's different sorts of methodologies or approaches for why they bring out different tools at different times, or for why they use a particular approach at a particular time. And it's all meant to be within the individual protocols very, very cohesive to include all of the elements that are important to maintain that integrity within the protocol. So if we're taking pieces of protocols and we're kind of gluing them together and making a Frankenstein protocol, it can be very, very difficult to defend because there may be tools or implements or aspects that are missed because maybe it is introduced at a different point within another protocol or another interview process. And so again, stick to one protocol. That being said, I think it can be very, very helpful to be trained in multiple protocols. I myself am trained in a number of protocols, and through the processes of learning the different protocols is really, really bolstered my skills as a forensic interviewer, and thinking ahead about different approaches or even different types of questions that could be helpful within a forensic interview. But when I'm conducting the interview itself, I want to stick to one protocol so I can defend that process as a whole, and so that I am being purposeful and using the correct techniques and at the correct time in accordance with the research that was used to build that particular protocol. So again, more. When we're thinking about our protocol, it's very, very important to know why you do what you do. I think about when I first started interviewing, I got to go through, on a localized level, a forensic interviewer at trial sort of course, and there was actually a person that co-taught that was a defense attorney. And one of the things that I'll never forget that she told me was, you know, think about when you're going to testify and you're going to defend your interview, what would happen if a transcript was created of your entire interview and the defense attorney asked you what your purpose was for every question that you asked. In our forensic interview, everything should be purposeful. And while that in itself may be a little bit excessive, right, we should be able to explain that to an extent, because even when we're asking a child what their name is or what's something that they like to do for fun, we're doing that for a purpose within our interview. I'm asking the child what they like to do for fun so I can do a narrative event practice with them or an episodic memory training with them. I'm not just asking them about what they like to do for fun just to, you know, eat up time with them. So I should be able to an extent to explain why I asked every single question that I asked. Again, part of this too is we want to be able to explain, just like I talked about with the MDT, if we had to make modifications or we deviated from the protocol, we want to be able to explain why that happened. So thinking about in a rapport stage, if you have a child that makes a spontaneous disclosure, you are going to move right into explore details. Your rapport stage is going to look different because the child made a spontaneous disclosure. So again, that is more so due to that flexibility of the protocol, but we want to be able to explain that the protocol is made to do that. It's a semi-flexible process, so it's totally, you know, appropriate. Or thinking here, the example of teen interviews, your language is going to shift a little bit because we want to make it culturally appropriate for a teen or adolescent. So I'm not going to be talking about children and kids. I'm going to be saying, you know, my job is to listen to people in this room. So our language is going to shift a little bit. I may use interview aids at different points with it in a teen interview. And again, it's not because of necessarily a deviation, but because the interview is flexible and is meant to center the child that I'm interviewing. Again, explain what the research says about your protocol. So thinking about that OJJDP white paper on best practices in forensic interviewing, that will explain a lot of the pertinent research within when you go through your protocol training. Oftentimes you'll also receive an outline or a binder or resource materials that explains some of the research that's going to be specific to elements of your protocol. So for instance, in Child First, we want to make sure, and we do include a lot of information on defending our use of dolls and diagrams, because we know that that's going to be a common area of defense attack. And so again, we want to know what research applies to our protocol, and we want to be able to explain the research within the process. So again, I think about sometimes where a defense attorney will find a piece of research that supports a hypothesis or a belief that they have that would be that would support their case, right? So finding a piece of, say, research that says that we should cease using dolls or cease using diagrams, and so they will bring that in and they'll ask you as an interview, are you familiar with this piece of research? And what we want to be able to do is, if we are going to have a situation where a defense attorney brings in an outside piece of research like that, one, we're not going to assent to it without seeing it. And if they agree to give you the time to review it, we want to look at the methodology and the practice that's reflected in that and determine, is this even reflective of what we do within the interview? Is this reflective of our practice and how we utilize these tools? Because if it's not, then it doesn't really apply to our protocol or to the practice. Again, when we're thinking about that research, I think being connected in with those national resources are important. For us at Zero Abuse Project, we also offer a lot of that continued education as well. And I think that, you know, things like the APSAT guidelines, the OJJDP white paper too, are great places to start for that foundation. So when we think too about some of the areas of research that we think are very, very important to focus on and to know, again, are the anatomical dolls and diagrams, and also thinking about the disclosure process. I train a lot on the process of disclosure and a lot of the dynamics that are involved in child abuse cases. And similarly to when we think about adult victimization, we know that a lot of the myths and stereotypes and beliefs that the general population has about survivors and victims of abuse and maltreatment and violence are in direct conflict with what the experience of that abuse and maltreatment and that violence is for that victim. So a lot of times what people perceive to be behaviors that are counterintuitive victim behaviors are actually, as we know, very much can be indicative or can be indicators of abuse or maltreatment. So delayed disclosure is a great example. There's a belief or a myth that, when kids experience abuse or maltreatment, they know what adults to tell. They'll come tell someone right away. They'll know what to say. I hear parents in prevention education say, my kid could never keep a secret about this, or my kid would come tell right away. But what we know is that in actuality, delayed disclosure is actually very, very common. And so this delayed disclosure dynamic is something that we want to be able to speak to and feel comfortable speaking to. Again, it's part of the training, the forensic interview basic training, in many of the protocols, because again, when we think about how our protocol is structured, it's structured to be able to address these different dynamics and address this process. And so again, it was made to understand that there's going to be barriers to disclosure, and these dynamics are going to be present within our interview process. And then also our anatomical dolls and diagrams. So we want as interviewers to sometimes be able to explain why there can be elements or a process of disclosure or dynamics that are present oftentimes in the form of blocks and problems that may seem incongruent with the experience of abuse or maltreatment, or may seem problematic to a particular case. So we're first going to talk about, again, that purposefulness, staying purposeful within our forensic interview process, and I'm going to go over briefly a little bit about dolls and diagrams just to point you in the right direction if you are defending your use of dolls and diagrams within the interview. So again, what we do, it needs to be purposeful and legally defensible. Again, remember that forensic interview, neutral fact-finding interview conducted by a specially trained interviewer. It's for that allegation of alleged maltreatment. It's with that multidisciplinary team. So we want to stay purposeful and legally defensible within our practice. Again, when we're thinking about diagrams specifically, it's really, really important to remember, and the biggest piece of advice I have is we don't want to assent to the application of research that isn't reflective of our process and how we're actually using them within our interview process. Again, there's limitations when it comes to research with regards to how they can study this particular issue, and so there can be sometimes, incongruence between how in an analog setting they're studying the use of these diagrams and even the relational aspects. So thinking about the child's relationship to, an adult researcher is different from their relationship to their grandfather that's a perpetrator. And again, so that all shifts how the children may interact with these tools, right? And so again, it's just really, really important that we are applying research that actually reflects how we do our work, and making sure that we're not assenting to research that doesn't reflect the practice. This is that position paper on dolls and diagrams, and this is really, really important to have because, again, it provides a synthesis of research that's actually relevant to how we use these tools within our process and what that purposeful approach looks like. And again, this is one of those elements that I will give to prosecutors that I work with, specifically, again, when I'm working with prosecutors that aren't connected with the multidisciplinary teams that I work with frequently, or that are connected into a lot of this ongoing research. Again, when we're thinking about the purpose for use, the diagrams, they shouldn't be used out in minimal facts or what we call a first response interview, so they shouldn't be used in field interviews. We're also not using them to have a body safety conversation within the forensic interview. In our protocol, the Child First protocol, we use them to either name body parts to establish common language, again, as a structure for the child to be able to talk about maltreatment, or within a protocol to clarify terminology used by the child. So sometimes post-disclosure, the diagrams will either be brought back out or brought out for the first time for the purpose of clarifying terminology that the child has used within their particular disclosure. When we're thinking about using them properly, again, if it's happening after open invitation as a structure to talk about maltreatment, we should be using unclothed, anatomically correct diagrams. The child should be able to do representational shifts. And again, in the protocol, we give that language for how that's done, but the child should see that that object is representative of them. They should be able to see that they can be projected onto that onto that two-dimensional object. The diagram should be reflective of the age and the ethnicity of the child in front of you. So we don't bring out diagrams that are reflective of the alleged perpetrator or who's assumed to be the alleged perpetrator within a particular case. Because again, that would be highly suggestible. It would seem that we were pointing or leading a child to a certain person or a certain direction. Because we use the diagrams pre and post disclosure, we're having the child use that tool with diagrams that are reflective of, again, their age and their ethnicity, and we're using both diagrams. Again, the other use, like I talked about then, is the diagrams being brought in for clarification purposes. And this should always be paired with maximizing open-ended questions. So we should never just let an indication on a diagram stand alone without further investigation or further questioning about that, right? So again, if a child is indicating something on an anatomical diagram, it's either being utilized to clarify a full verbal disclosure that the child has already made, and or we're going to continue to question and ask for further detail to get that high definition detail about what the child is describing particularly. Again, we aren't using diagrams that are gender neutral or closed. Again, we don't want fantasy or make-believe in our interview, so we don't want the child to be identifying body parts that aren't physically visible or present on those diagrams. Same thing with closed diagrams. The child literally can't see a penis on a closed diagram. We aren't using diagrams as a last-ditch effort to get a disclosure, and we're not using them for body safety. So remember, our purpose within our forensic interview, we're not confronting a child about their perception. We're not doing, body safety training or teaching within that forensic interview. Again, I think that those things from an advocacy perspective, a mental health perspective, are extremely important. Is talking to the child about that body safety, about boundaries, about safe and unsafe and okay and not okay touch, but it's outside of the scope of our forensic interview. So we shouldn't be using the diagrams in order to facilitate conversation about that within the interview. Again, like I had talked about, when we're talking and we're applying research when it comes to diagrams or dolls for that matter as well, we want to make sure that we are considering the findings and implications of research that matches our actual practice and use. Again, some of the issues and problems that you will see within the recent research and that we want to look out for, particularly if a defense attorney is asking you to look at a particular study or ask you if you're familiar with a particular study, is again the elements. Does it replicate what real world interviews look like and what the nature, the relationships are within those interviews? Again, not addressing the reluctance of the child to report, so thinking about, the ways that an anatomical diagram can be helpful within an interview process to, as a memory cue or based on the child's age, right? False reports are not probed for details. So again, this is the example of what I was talking about with using an hourglass questioning technique or using open-ended questions. Afterwards is that when a child indicates something on an anatomical diagram, we should be asking for additional details all about that, making sure we're getting that high definition picture, right? Using gender neutral diagrams, using human figure diagrams that are fully closed or where the body parts are suggested proportions or imprecisely located. Again, sometimes in some of these studies, the human figure drawings, so HFD is human figure drawings or anatomical diagrams, were being used when the child had indicated that they could conduct representational shifts. So again, if the child doesn't see that that image is representative of them, that can lead to, a false disclosure or can, cause them to be using them or indicating things inappropriately within an interview. So again, here's just some examples of anatomical diagrams that we don't want to be using within the field or can be problematic in use. So again, here's a couple examples where these diagrams, they don't have body parts. Again, some of them can be pretty creepy as well, so not very helpful. And these are what were being used within these studies. Again, when we think about diagrams such as this, we're asking the child to, indicate body parts that aren't visibly present here. And again, we're always trying to gate out within our interview process fantasy and make-believe and all of those pieces. So why are we asking the child to infer or project or identify something that isn't on these drawings? There's also inappropriate drawings such as this that have been used as well, which we don't want to be using in practice. They're not reflective of the children that we are serving and interviewing. We also don't want to be bringing in fantastical elements. So we've heard about sometimes that, a gingerbread is being used or a picture of Shrek is being used because the idea is that it's more child-friendly, or also have heard about a stuffed animal or things like that being used. What I want to say is that with our tools in the interview process, whether it's diagrams or dolls, a lot of times the barrier is our discomfort in using them as professionals. Children, body parts are just body parts to children unless there's been some experience or some context that's been given to those body parts that makes them have an adult meaning or a different sort of meaning. But children have names for body parts, and again, if they don't, we just move forward within our protocol. It's not a test. We're not forcing them to talk about anything, obviously. But again, it's not more child-friendly when we're using a gingerbread or a Shrek, and in fact, it can create issues within our cases. There's an example from the state of New York where there was a child where they were given a gingerbread drawing, and they were asked to name, the person pointed to the belly button and said, what do you call this part of the body? And the child said a purple gumdrop. Because when you look at this picture does in fact have a purple gumdrop. So it was an example, again, of a child literally naming what they saw, literally naming what was there. But again, because of this tool being used inappropriately, it created problems because it was this fantastical element that was brought into the interview process. So we want to avoid that by really using the appropriate tools in the interview. We've talked about this a lot too. Some other things is that, when we're using dolls or diagrams in the interview, we're always using them with a purposeful introduction, so it's contextual. We're utilizing them with that explanation and that instruction to the child. And again, we're using that hourglass technique. So if we're using the diagrams, we're pairing it with sometimes more direct questions, like a yes or no question to clarify, but we're always going to be opening it then back up after we're finished. Again, here are some examples of the diagrams that we utilize in Child First or Finding Words. Again, there is research out there too that is supportive of the use of dolls, diagrams, specifically when you look at the APSAC forensic interviewing best practices as well as the OJJDP white paper, which again are two of the documents that offer a lot of guidance for us as forensic interviewers. Both acknowledge the use of dolls and diagrams within our field. And there is research out there that does have encouraging inclusions and does talk about the use and the appropriate use of diagrams or human figure diagrams or drawings within the interview. Even some of this research that has skepticism does acknowledge, like this particular study, that when used to assess the child's knowledge of body parts can help the interviewer in assessing with other cognitive functions. So even sometimes when there is skepticism, there still were conclusions that supported the use of diagrams within the interview. Again, advantages of using media outweigh the disadvantages. They should be used in a planned manner. Again, it should happen within the context and be used purposefully with intentionality behind the instruction and introduction of those tools. Again, doll research is very, very similar. Again, it's all about how we use the dolls. So we shouldn't be using them pre-disclosure. An interviewer needs to be trained to use them. They should never be used to play, and they always require representational shifts. So if the child can't see themselves projected onto that object, they really shouldn't be, utilized within the interview process. So again, we want to use research that's reflective of all of these elements being present in accordance with how we use them within our protocol. So moving back into talking about, again, the testifying pieces in our preparation, again, that just allowed us to just explore a little bit some of those common defense attacks, specifically when you're using those tools within the interview. Similarly to what we were discussing before, again, we talked about the importance of knowing those roles of those multidisciplinary team members, understanding and articulating deviations in our MDT protocol, how we approach the process. Again, we should never have a child's interview stand alone or a child's statement stand alone. So again, as interviewers, part of our job is to try and collect as much detail to corroborate, to give you elements to either corroborate or refute. So we need to go ahead and do that as much as possible. I've even seen some cases, I think about an investigator I worked quite a bit with in one of the jurisdictions that I worked in, and one of the things that she would always do is even when she had a non-disclosure forensic interview, she would always go and try and look for, are there things I can try and corroborate within the child's initial disclosure, or at least go and do that perpetrator interview afterwards, and sometimes actually had, a full confession when she went to go do those suspect interviews. Again, we know that a lot of times there's a lot of reasons why a child may not disclose within a formal interview, and it doesn't mean their initial outcry, wasn't credible. And she always did that follow-up and had some really amazing outcomes as a result of that follow-up. So again, corroborate, corroborate, corroborate. That's what we're gathering these elements for, right, is to either corroborate or refute the allegation. Educate all team members on the developments in the field of forensic interviews. And again, record your interviews. That documentation is going to be so important when we're thinking, especially as I had talked about, sometimes we're looking at many years down the road before you're going to be going to trial and testifying to that interview. And so having that recorded interview helps us to refresh and really understand holistically everything that happened in that interview, that those tears that came down at that certain point, the way the tone of voice changed, the way that the child approached certain topics or they covered their face. That recorded interview allows us to refresh our memory of all of those elements. It's important to also know your jurisdiction. So know the type of court that you're going into and the limitations of what you can and can't talk about within the type of court. Know your case file. I think about this, sometimes people will bring reports with them up on the stand. We still want to know what is in that case file and what's in that report, because if you're up on the stand and every other question you're asking if you can refresh your report, the message that is given to the jury is that this case isn't really super important to you, or it wasn't worth taking the time to refresh your memory about the case. And it comes off as, being, not very prepared, or that this child's case, wasn't as important to you as other matters. So we want to know that case file. Understand the type of witness that you will be and be purposeful about this. I had a situation where I came in and was a lay witness, and unknown to me, the prosecutor converted me into an expert witness halfway through my testimony. Again, it ended up being okay, but that's something that, if I'm going to be used sometimes dually within my testimony as both a lay witness as well as an expert witness, that's something that I want to try and be planful with my prosecutor, so that I can talk about what the scope of that is going to look like, and what the nature of my testimony is going to be, because there are certain aspects, especially with an expert testimony, where I might have a lay knowledge of that because I'm part of the team or I'm adjacent to that, but that doesn't necessarily mean I'm an expert on it, right? I'm an expert on forensic interviewing. I'm an expert on dynamics. And just because I may know something or know about a dynamic within the team doesn't mean I'm necessarily an expert on it, and it wouldn't necessarily be appropriate to receive questions about that. So really delineating, are you a lay witness, are you an expert witness, or are you going to be a combination of both? And again, thinking then too about, if you're a lay witness or an expert witness for that matter, how far can you go and what that scope is going to be. Also talking about your rules of evidence, so thinking specifically if there's co-current cases that are going on, what you can talk about, what you can't talk about. And obviously too, as a forensic interviewer, we're not going to be able to approach or make an assessment of whether we think the child is lying or telling the truth, or whether we believe the child. That's outside of our scope as a neutral fact finder. Again, it's our investigative partner's job to corroborate or refute, but we aren't forensic evaluators. We're forensic interviewers, so we're neutral fact gatherers, right? We talked a little bit of expectations of judges and juries, so it is important to kind of familiarize yourself with that as well. And being able to speak to, again, that peer review and that ongoing training. When we're thinking about that practice and preparation, thinking about how the preparation begins the day the case is reported. So what has that entire trajectory been like? Thinking again too about getting on the same page with your prosecutor about co-current civil and criminal matters that are going on? Does there need to be a conference to talk about which one takes precedent or which one doesn't, or if there's elements that can't be discussed because of the co-occurrent cases? Documents, again, reviewing your interview, and again, also, thinking about how the interview fits into the entire investigation, which we talked about, and making sure that we're understanding our role within the context of that entire investigation. When we're thinking about testifying particularly, one of the things that I want to say, I know that prosecutors are extremely busy, but for me as a forensic interviewer, I think it's so, so important to meet with your prosecutor prior to your testimony. Again, I like to give them the resources that I had discussed earlier, but the other thing that I like to give them, and it comes to this piece about direct examination, is I like to actually go through, and when I review my interview, I look for any issues or problems that may be present within my interview. So if I forgot to follow up an interview instruction when the child says, I don't know, I'm going to identify that and let my prosecutor know that. Or if I forgot a part of my report phase, I'm going to identify that and let my prosecutor know that that could come up. Or maybe, there's issues with the child jumping around or running around in the interview room. I want my prosecutor to know that ahead of time, and we can kind of strategize about, about asking about the dynamics of child abuse, or asking about observations within the forensic interview. Those types of pieces can maybe give me an opportunity to explain why some of the things looked the way that they did, right? So again, I like to just be very honest and upfront with my prosecutor about what some of those issues and problems may be within my forensic interview, because a lot of times, again, if we concede to those or we can bring those up and explain those in direct, there's going to be less for them to attack during cross-examination. I also want to familiarize my prosecutor with the interview aids that I use, if I use them, any problems that maybe emerge with the use of those interview aids, and again, familiarize them with the research that supports what I did, and explain to them and allow them to help me explain what my purpose was. I talked about this a little bit too, but we want to make sure that we're using simple, concrete language that's not just a performance for the people that are in our field, but that is accessible to the folks that need to understand what we do within this particular arena, which is our jury. So also avoid those acronyms as well. Two, when you're answering questions, looking at the jury when you're answering questions, you're educating them, you're telling them about what you do, and so making sure that you are, connecting with them and looking at them when you're answering questions. With our cross-examination, we want to be mindful of our nonverbal body language and our affect. So again, part of the way that I see it is that most defense attorneys know that it's not a very good strategy to cross-examine a child in a very aggressive way. You are the person that is the closest to the child without being the child. So a lot of times, a lot of the more aggressive approaches to cross-examination and the defensive strategy will be targeted towards you as well as your other MDT members. So we want to make sure that we're being polite. And that we are, staying very neutral within our nonverbals. Don't let it kind of rattle you. We want to also be careful when they're asking things like, do children lie? So we don't want to, again, they're trying to diminish that child's credibility or create the shadow of a doubt, but it is true that children lie. And so we don't want to say something that's not supported by research. Again, this is something where we can have our prosecutor afterwards help us rehabilitate a question like that by maybe in redirect asking you about the research about children lying and about, what that looks like, right? Making sure you don't answer more than what you're asked. So don't give up information or over answer. With yes or no questions, so most of the times the structure of the cross-examination questions are going to be yes or no questions. If you can't answer it with a yes or no, ask if you can elaborate. And again, if you are not allowed that elaboration, that's something that you're going to want your prosecutor to pick up on and then address and redirect. So one of the ways that I will cue that to my prosecutor is if there's something that I want to explain more, but I'm being pushed into giving that yes or no answer, I'll say, of course not. And that cues to my prosecutor that this is something that I want them to ask me about in redirect so I can further elaborate. I think, too, it is okay. I think a common defensive strategy as well is to get very rapid fire in questioning and just taking, that second to take a deep breath to make sure that you're interpreting that question properly. You can ask them to repeat the question if you need to. So again, we can just take our time and make sure that we're understanding correctly and properly. Again, we've talked about this a lot. When defense attorneys will attack forensic interviewing, a lot of times it's about that protocol. So using those resources like the OJJDP white paper to really show, yep, this is the agreed upon best practices in the field and that body of research that supports that. But then in order to be able to say that, we want to make sure that we didn't mix and match those protocols, right? And that we are then staying true to process and practice as much as possible. Always remembering that there's no perfect interview, right? Just to talk about a few additional resources and then we'll get to questions here. But, one of the things us at Zero Abuse Project, we are here to help you. So everything from our forensic interviewer at trial course, which is a phenomenal preparation for forensic interviewers. We also do a national peer review program too. It's totally free and is a great resource if you don't have other peer review opportunities within your jurisdiction. And please reach out to us if you're going to testify and you have questions or there's issues or problems, both as a prosecutor and as a forensic interviewer. Please connect with us because a huge part of our job is doing technical assistance to support you in that. Included, too, in the handout, there are citations for the research that I invoked over the course of this presentation so that you will have that as well. If it's helpful as well, the resources that were put in the chat and are included within the handout section, too. So with that, I think that we will move to questions. And I will... All right, so I'm not seeing how I turn my camera back on. I apologize for that. Awesome. Oh, phenomenal. Thank you so much, William. Okay, so we will come here for questions. I see a few questions. If not made for the purposes of medical diagnostic and treatment, how does a non-doctor's testimony survive a hearsay objection? So I do want to be clear that for me personally, I am not an attorney, but in my experience, when there's been either the way that it is brought in under Crawford is that the child has to testify. So in order to bring in the forensic interview, the child has to testify to bring that in, then to have you testify as the interviewer. And so again, that would be a question that would be great for more specifics on with our legal staff. We have a few different attorneys that we work with at Zero Abuse Project, but that is what I've seen in my personal experience. So how does the forensic interview establish that the child can do a representational shift? Yeah, so I'll just talk through a little bit about this. So within the child first protocol, and again, different protocols will address that differently, it's contingent on the child's age. So I'll give an example for a child that is younger. So what we will say is when I introduce the diagrams, the next thing that we're going to talk about is parts of the body, because we all have different names for different parts of the body. And I want to know what you call parts of the body. And I want you to know it's okay to use any words in here and that there's no right or wrong answer. So I have two drawings here. Which one has body parts like yours, or which one looks most like you? And I show them both of the diagrams, and then I have the child select the one that they feel is reflective of them and looks most like them, and that they can see themselves projected in. So again, there's a few different approaches and ways that we do that. Again, it is contingent on the child's age, and also is contingent on when and where we are bringing the diagram into the interview. Yeah, absolutely. So a question about, can you explain the of course not strategy again, please? Absolutely. So this is something that I would connect with when you're doing that pre-meeting prior to going to trial with your prosecutor. One of the things that I will talk about is that I use of course not answers when I'm being pushed to give a yes or no answer about something that is more complex and they're not giving me the opportunity to elaborate on. Or something where they're trying to make an assertion or a statement of fact that is not reflective or is incorrect. So I will say, of course not. You know, again, appropriately and using appropriate tone in my testimony, especially in cross-examination, to indicate to my prosecutor that I want them to ask me something to allow me to elaborate or to allow me to speak to why that statement isn't reflective of a dynamic or reflective of practice in the interview or whatever that dynamic may be. Good question. Other questions? What is the youngest that a child should be interviewed? So when we're thinking about the age that a child should be interviewed, it will depend on how much verbal communication a particular child is able to engage in. I've seen a 2.5-year-old be interviewed, typically 3 years old and older, but again, I've seen, like I said, a 2.5-year-old that was more verbal, that was involved in a forensic interview. It really depends on the child's ability to participate in the process. And so some of that can be ascertained through an advocate or team member talking with, say, a parent prior to the forensic interview to understand more about how the child communicates or other sorts of strategies for gathering information about the child's developmental level and abilities prior to the interview. Yeah, could you give examples of the types of questions to expect when testifying as a lay witness versus an expert witness? Yeah, absolutely. So when I'm thinking about, well, with both lay witness and expert witness testimony, you are going to need to answer a lot of those questions that establish, again, who you are, what your training is, what your background is, and about those elements of our field that are pertinent to understand to be able to speak to the dynamics of a particular case or to offer an expert opinion. So regardless of whether you're talking as a lay witness or an expert witness, you do want to make sure that you are comfortable answering those foundational sorts of questions. Where we get into the differences, a lay witness is going to be asked about specific details about the case, how the child presented within the forensic interview, about the specifics of the process that happened with that particular child. So, for instance, an example would be, as a lay witness, I might talk about my observations within a forensic interview, such as the child, pulling their hair, or scratching themselves, or starting to cry. And in my lay role, I'm just speaking to what I saw as a person that engaged within that interaction with the child. So I'm not necessarily giving any sort of context or speaking to what that means or doesn't mean within an interview. I'm just speaking to my observations and what occurred as a person that participated in that process with that child, or speaking to what the child said to me or statements that the child made over the course of the interview. Expert testimony might be a little bit different because I may be asked questions about, what are behavioral signs or potential behavioral indicators of a child that has experienced sexual abuse. And I may speak to some of those behavioral patterns that may be present in a sexual abuse case. Or I may be asked to talk about things like, why a disclosure is delayed or what that process of disclosure looks like. So giving additional information that allows a jury to interpret or to understand what the child's statement was. So expert witness is more about some of the contextual factors that may give additional information for a jury to discern or understand more about how, when, and why a child disclosed, versus my lay witness accounts is going to be literally what I experienced, what I saw, what was said to me in that experience. Please let me know if you need additional clarification or have additional questions about that. Other questions. So I heard the answer regarding the youngest that a child should be interviewed. What about older children? If the child is a normal functioning 17-year-old, for example, should that interview be conducted by a police or forensic interviewer? So I will say, as a professional forensic interviewer, I feel like there can be a lot of benefits to conducting this sort of interview with this age group. So I've done teen and adolescent interviews as well as young child interviews. I've also done interviews with an adult where for some reason or some dynamic within the particular case, it was decided that the Child Advocacy Center or that sort of approach within the interview would be a better fit or more appropriate for that adult. What I say about a 17-year-old is, we're always trying to get the high definition detail and try and understand all of the elements, all of the factors that may be relevant or pertinent to that child's statement, right, to that child's experience. So there sometimes are things where a child may feel comfortable telling me that they were using before it happened or they were doing something they weren't supposed to. As a professional forensic interviewer, then they would maybe tell a law enforcement person that they perceive could get them in trouble or that they think are going to write them a minor consumption ticket, right, or something like that. I also think, too, within our forensic interview protocols, we do have flexibility with our approach. So say, I think about with my teen and adolescent cases where there have been multiple victimizations or the child's highly traumatized or it's commercial sexual exploitation or poly-victimization. Using an expanded or a multi-session process sometimes can be very, very helpful than conducting, a law enforcement interview or an interview in another setting. And all of that is defensible. So I can speak to why, that expanded process or multi-session process was a good fit for that child and can still defend that interview that maybe looks a little bit different than a traditional interview. So I'm a big proponent of interviewing teens and adolescents and older children, regardless of developmental level, at a child advocacy center because of all of the dynamics that we know are involved in these particular cases. And also advocacy is really, really important too. And so, what's being lost for that child when they aren't able to get those multidisciplinary team services? So that advocacy, that access to medical, that access to mental health, right? We want them to have all those wraparound supports and services. And, particularly I think with advocacy, sometimes that can provide supports and helping them kind of understand and give meaning to what's going on in a way that they may not have access to in other areas. Other questions? Yeah, absolutely. I know it can take a minute to type, so I'm just going to let folks. Are there good, relevant, oh, I'm looking at the wrong box, excuse me. Are there good, relevant case files for study? I don't think I understand your question. So if you could offer some additional clarification, like a sample or a mock case file to study, and then if so, if you need some additional time to explain, you can always email me and we can talk through it more. Can you speak to handling a subpoena from the defense? So I've seen this happen a few times. And again, I think it's a question of what exactly they're asking for. So, you don't typically see the defense attorneys, offering a subpoena for a case where they're defending a perpetrator, I mean, it could possibly happen. And then obviously with regard to expert testimony, that will be at the discretion of your agency or within your professional role, whether or not you would do that expert testimony or be retained in that way by the defense. You know, I will say this is something to be careful about. I think especially if you work for a child advocacy center, you will sometimes get calls. I think about a case that I had one time where a person had called. It was actually in domestic violence field, but it was a perpetrator, alleged perpetrator, who had called and asked me some questions on the phone. And then later on, I found out that it was actually with regard to order for protection, harassment order sort of realm. They cited that they had talked to me and said, you know, well, I talked to this person and they said that I could file a harassment order, an order for protection, when that wasn't, you know, what I had said. I explained the parameters of, you know, here are the elements that are involved. If you think that an order for protection or HRO would fit you, you know, here's our hours that you can come in for advocacy. But again, we want to be careful even about answering questions over the phone when it comes to defense attorneys and things like that, because sometimes then they'll cite, you know, I had this phone call with this person, or especially given your role, you know, they offered this advice or this opinion. So we want to be careful about that. Did you cover autistic children? So we do have some additional training through Zero Abuse Project on interviewing children that have a variety of different types of developmental disabilities or cognitive disabilities, and so that's definitely something we can provide. Okay, all right. So I think I just do want to say on this next slide, my email address is here, and I know there's a few questions that we didn't get to, and so I do want to direct you towards my email. I'm so happy to follow up if there's anything that we didn't get answered today, and we do have a few last things to do here before we wrap up, and I want to respect everyone's time today, but please feel free to follow up. With regards to some of the questions specifically around case law, I would feel more comfortable connecting you with our legal staff about those. I can make sure that I get you the appropriate information from that particular lens. So please email me and I can connect you with Robert and Victor to have them best and most appropriately answer those questions. So again, thank you so much for spending your afternoon with me. Don't forget, I'm here to support you. I'm here to help you, even to talk through if you get subpoenaed, what do I do next? What should this look like? Please get in contact with us, myself or someone else from Zero Abuse Project. We're here to support you. So again, thank you so much for spending the afternoon with us, and I hope everyone stays safe out in the field. And again, just want to say thank you too for everything that you do for children. They're safer because they have you advocating for them and working to keep them safe every day. So thank you so much.
Great. Thank you, Rachel, for a wonderful presentation this afternoon. We're getting definitely kudos for you in the chat here, so everyone agrees. Great presentation and great presentation on the information offered today. So before we wrap up, just a couple of last-minute items for our audience members. If you'd like to get in contact with NTTAC, you may do so through the information on this slide. If you'd like to, you can also select the link that's on this slide in order to register for the NTTAC listserv, or you can text 22828 to sign up for our NTTAC listserv. You'll get information about great webinars like the one you witnessed for today. You can also check us out on Facebook, OJJDP TTA on Facebook, to check us out about upcoming events. Again, if you'd like to get in contact with the TTA Help Desk to find out information about the JUVE-Just and any upcoming events, you may do so through the phone number and the email address here. You can also select the link here to visit OJJDP's website, or you can click the link here to sign up for the JUVE-Just, where you'll be able to see and register for upcoming events that we will host soon. Do you have a training or technical assistance need? Well, if so, feel free to submit a TTA request via the TTA 360 platform. You can access that platform on the URL that's displayed on this slide. Remember, this webinar is being recorded and will be provided on our NTTAC YouTube page. and you can follow up with the OJJDP TTA Help Desk if you'd like to receive supporting materials related to any of the webinars that you see on our website. And join us for some upcoming webinars that we have. We have a webinar with our colleagues with the Western Regional Children's Advocacy Center and the Innocent Justice Foundation. You can feel free to click on the Register Now link to register for each of those webinars. You can also select the Learn More to learn more about each of those webinars. And again, we have webinars coming up with our colleagues with Zero Abuse, one coming up in November. Please click the Register Now button to register for that webinar. You can also select the Learn More to learn more about the webinar coming up in November with our colleagues with Zero Abuse. And again, another one with our colleagues with Innocent Justice. Again, feel free to click those Register Now buttons in order to register for those webinars now. There's plenty of room and plenty of space for you to register and join us again in the future for another webinar. And then lastly, I'm going to end us with a quick poll, and we want to know, how do you plan on applying the information from this webinar in your work? Please note that this is multi-select, meaning that you can go in and you can actually select multiple options here. So take a moment to please let us know, how do you plan to apply the information from this webinar in your work? And again, this is multiple select, so feel free to select multiple options here. I'm going to leave this up for a couple of more seconds. But again, thank you all again for joining us for today's webinar. Everyone have a wonderful afternoon. Goodbye.
The host has left the meeting, so at this time, the meeting will come to an end. Thank you and goodbye.